amongst the wild threads of history and the myriad of paths. My path saw the Imperium rise from the ashes left in the wake of the Great Revolt. Thou shalt not make a machine in the likeness of the human mind. With that commandment, new avenues of human potential were explored. Mentats, Suk Doctors, Sword Masters, and the mystical Bene Gesserit Sisterhood. But it was the Navigators and their monopoly on space travel that set the conditions for the Imperium. But I am telling you of the universe you already know. Let me describe the one you do not. In this other universe, my mother, Lady Jessica, consort to Duke Leto Atreides, gave birth to a daughter, a girl they named Ariste. Because of her obedience to the Bene Gesserit, Lady Jessica is trained as a truth-sayer. Because of that training, Lady Jessica was able to detect Dr. Yue's deception. Because of the forewarning of his betrayal, House Atreides survived the Battle of Arrakeen. Because of their survival, the Emperor declared a full-scale war of assassins. Because of the war, the Sardaukar were deployed to ensure spice shipments continued without interruption. Because of the Sardaukar, the Fremen were eradicated. There was no Muad'Dib, no Lisan al-Gaib, no Kwisatz Haderach. I see a universe where I, Paul Atreides, was never born. All my visions lead to horror, except this one. This one leads to you.
Hello. Why does that look wrong? Oh, because I need to flip that. That's why. Selfless. Hello, hello, sir. How are you? Thank you for coming to hang out. Thank you for claiming first, by the way. You're good? That's all I care about, buddy. All I care about, my guy. I'm trying to remember how to actually like transform this. More PC tink selfless. You sound like me growing up. You sound like me growing up. I'm all right. Not bad. Just getting comfortable, queuing up for just getting ready to do homework and play Dune. Because this doesn't take too much thinking and I can just listen to my textbook. You know? Yeah. Right here. All right, let's get ready for the book. You can do a private server if you really want to, but like I'm not paying for it. I don't care enough to, you know what I mean? It's just something to pass the time. Let me close this. All right, you ready for the fun excitement tonight? You buckled up for this? By the way, congratulations on first. Appreciate it. Let's go.
Chapter 10, Sex Discrimination. Chapter Checklist. Understand the need for a prohibition against sex discrimination to counteract historical stereotypes. Learn that men are also protected against sex discrimination. Appreciate that women are often discriminated against not solely because they are women, but also because they have small children or elderly parents. That is, sex plus discrimination. Be aware of the limited exceptions for bona fide occupational qualifications. Be apprised of potential violations of the Equal Pay Act. Be familiar with the impracticability of comparable worth. Appreciate the wide latitude given to employers in setting dress codes and grooming standards. Learn that customer preferences are not a valid reason to discriminate on the basis of sex. In the news, Kyle Hunter, a weatherman for Fox 5 in San Diego, sued CBS when he was passed over for job openings at KCBS in San Francisco and at
Remember how I told you about the CPU? I remember you were having issues with your GPU. Oh, I didn't realize you had CPU issues as well. So you got a bad CPU. Yeah, I know there was a bad batch. Yeah, no kidding. Like, I would have thought that too. But it sounds like you got one of the bad batches CPUs, unfortunately. Good. I'm glad to hear that. Trying to figure out if there's anything else I want to do to my base, or if I just want to leave it as is. I know I eventually need to build bigger. I just don't know what that looks like. I gave myself a lot of room in here to build and customize and do stuff with. We can change up all these floors. Granted, here is the base floor. And I've purchased enough land that we can build this way eventually. I will never be able to build this way. Because of, you know, that, but we'll figure it out. Man, you are infinitely beyond what I care to do with computers. I have no interest in undervolting or overclocking or anything. I'm too basic when it comes to stuff like this. Oh, we're actually pretty full on water across the gate here. You know what? I'm gonna go collect a little bit more blood real quick. Yeah, that's an interesting issue. I never have problems with my PC getting too hot. For instance, let's open up Armory Crate. That'll give me the temps. Like right now, middle of the daytime, full, whatever you want to call it, GPU 80% usage. About half the GPU memory is being used. It's sitting at 50 degrees Celsius. So roughly 120 degrees, right? CPU sitting at roughly 80% utilization. Sitting at roughly 57 degrees. I mean, I understand why mine is super high right now. It's because of this game.
Reveal yourself.
Oh, there's two of you here. Wow. And there's a lot of light particles and sand particles, so I mean, you can tell there's a lot of light intensity in this game, so. The other thing that helps me out too is I have a box fan sitting on the floor next to me right here that literally blows air through my room and just pushes the hot air out into the AC intake.
There's someone here.
There is someone here. Thank you. Yeah, it's graphically intense and it has everything to do realistically with the lighting. You're in a big open desert. The sun is intense and bright, so you have a lot of shadows, a lot of particle effects. Yeah, so it is. Literally, mine has I have a box fan to my back left, I should say. So along the ceiling, I've got two air vents that blow air up and over. The box fan pulls this way, pushes it along the side of my chair right into my CPU, and then airflow pushes air out. I want more blood. How are you? How is Toast? Oh, I always do. I'm very cognizant of airflow. That came out in the PS3 era of me gaming. Because towards the end of playing Final Fantasy XIV, I was noticing my system was super hot, and I looked up to see the fan, to see how the fan was flowing, and where the air intake was, and I'm like, oh my god, this is terrible. This is like the system is constantly choking itself out. What is that about?
Eyes on target.
Come on.
Got him. Where's my backup?
Come on, you just ran over here. I just saw you. Boom. No! Oh, I lost shield. Oh, crap. I thought I blocked that. There we go. Okay, we're good. That's good, right? I mean, you're avoiding hassle. She's doing good. I don't think I can do this. Oh, I have another one. They call me Dr. Blood. We're looking for some water at the moment. What does sucking their blood do? So, sucking their blood. Give me a second. I'm looking for their water storage. I thought they had one. I'm just feeling lazy at the moment. There it is. I knew they did. Perfect. So, draining their blood lets me put it into these blood pouches right here. I've got these two, right? So we're gonna run there. And we deposit it into the blood purifiers. Deposit all blood. And what this allows us to do is extract water from their blood. Now, I don't have a massive storage network. Like, I've got these two little ones, right? These are mostly full. I've got these 3 big containers that are, like, pseudo-full, not overly full. So, the nice thing is how the game is designed is that because these are all together, that it counts as one circuit. And as you can see here, my circuit is 71,000 of 87 milliliters full. The 71,000 of 80. So these two are purifying out the water from blood to make it usable drinking water. I would say yes, except for the fact that it very much is just water. So the fun thing is, I also have one of these. Now, this is called a Fremen Death Still. And what you do is you put a body in here, and it drains all the water from a body, as opposed to me having to fill up little blood banks to do whatever. So funny enough, like, I have a bunch of the bodies stored up right here. These have all been, like, main people, like, main story people that I've needed to kill. I'm like, meh, I can do humorous and just take story bodies. I don't think I saved that. Nope. Excuse me. There you go. Blood stuff. Yeah, I'm kind of collecting them as trophies, but then, just destroy their body when you drain it for blood. Selfless, I miss you, and I feel like the only time I see you is when I happen to wander into Mudstream. But I'm glad to hear that things are going well. We should catch up and do a phone call sometime. And I'm going to get listening to schoolwork here. I will catch you later, sir.
All in Los Angeles. He claimed that be apprised. Chapter 10, Sex Discrimination.
All right,
Chapter
let's go.
Checklist. Understand the need for a prohibition against sex discrimination to counteract historical stereotypes. Learn that men are also protected against sex discrimination. Appreciate that women are often discriminated against not solely because they are women, but also because they have small children or elderly parents. That is, sex plus discrimination. Be aware of the limited exceptions for bona fide occupational qualifications. Be apprised of potential violations of the Equal Pay Act. Be familiar with the impracticability of comparable worth. Appreciate the wide latitude given to employers in setting dress codes and grooming standards. Learn that customer preferences are not a valid reason to discriminate on the basis of sex. In the news, Kyle Hunter, a weatherman for Fox 5 in San Diego, sued CBS when he was passed over for job openings at KCBS in San Francisco and at Call in Los Angeles. He claimed that television stations placed more value on feminine attraction than on meteorology competence in the selection of television weather broadcasters. CBS countered that Hunter's claims are without merit. Hunter retorted that his years of broadcasting the weather for several known weather stations as well as his membership in the Royal Meteorological Society render his credentials far superior to those of the two women hired. In fact, Hunter claimed that the two women hired to broadcast the weather had no experience at all. A spokesman for CBS said that the company was well aware of Hunter's background and decided to hire other qualified individuals. Is CBS's preference for young, attractive women to serve as announcers of the weather forecast a form of sexual stereotyping? Introduction. Case 10.1, 10.5. In the past, a person's sex was considered a bona fide occupational qualification. Stereotypes ruled. Men were physicians, lawyers, construction workers, and police officers. Women were nurses, flight attendants, secretaries, and teachers. This arrangement had the effect of discriminating against men and women in certain job classifications. The effect on women, particularly with regard to higher-paying positions, was noticeable. Women and men must be treated equally in all aspects of employment: hiring, compensation, training, transfer, and promotions. For example, prescribing limits for lifting or carrying weight just for women or for working before or after childbirth are prohibited. Any provisions or benefits must be provided to both sexes. Job requirements must be the same for male and female candidates. Employment perspective. Eric Freeman is a vice president at Bulls and Bears Incorporated, an investment banking firm. There is an opening for an assistant vice president to work directly underneath Freeman. There are two in-house candidates, Tom Foligno, a competent securities trader with 2 years of experience, and Mary Michaels, a senior bond trader with 7 years of experience. Michaels' experience and competence are clearly superior, but Freeman selects Foligno because they have common interests. They go to the hockey games after work and have a few beers together. Freeman and Foligno are both single, whereas Michaels is married with children. Freeman and Michaels have nothing in common outside of work. Does this qualify as sexual discrimination? Yes. Freeman's decision is not based on job performance, but rather on personal interests he shares with one candidate. Men are also protected against sex discrimination, which occurs when individuals of one gender are favored in employment decisions over the other gender under Title VII. Although men are not victimized as often as women, there are occasions when men have been treated unfavorably because of their gender. Sex discrimination occurs when individuals of one gender are favored in employment decisions over the other gender. Sex plus discrimination. Case 10.2. Discrimination may occur against an individual not solely because of his or her gender, but that fact coupled with another may be its cause. This is sex plus discrimination. Women with small children, women in childbearing years, and women taking care of elderly parents are all examples. Sex plus discrimination may occur against an individual not solely because of his or her gender, but that fact coupled with another circumstance, such as women with small children, women in their childbearing years, and women taking care of elderly parents. As part of their interview process, some employers endeavor to discover if a female applicant has small children. It has been their experience that mothers are preoccupied with worrying about their children. In addition, many employers believe if the child becomes ill or gets hurt, the mother will leave work immediately. This behavior can be disruptive to the workplace. For that reason, the employer may nonchalantly ask the female applicant where her children go to school. The response will indicate whether the woman has children and, if so, what their ages are. The
That's
employer can then
terrifying to
generally
think
refuse
about.
her or deny her for another reason. This is discriminatory behavior.
Yeah, no
Bona fide
kidding.
occupational qualification, BFOQ. Case 10.3, 10.4. The bona fide occupational qualification, BFOQ, operates as a defense to a suit for discrimination with regard to religion, national origin, gender, or age. The first 3 defenses are found in Title VII, while the Age BFOQ is found in the Age Discrimination in Employment Act, ADA. The courts have narrowly construed this defense, limiting it to job requirements that are essential to the job or are at the core purpose of the business. Mere job relatedness is not sufficient. Bona fide occupational qualification, BFOQ, operates as a defense to a suit for discrimination with regard to religion, national origin, gender, or age. The courts have narrowly construed this defense, limiting it to job requirements that are essential to the job or are at the core purpose of the business. Employment perspective. Nancy Hartwig attended Podunk University, where she was a star basketball player. She later became a
Podunk
women's basketball
University.
coach at Premier College, where she won the national championship 4 times. When a vacancy arose for the men's basketball coach at her alma mater, she applied. Although Podunk's administration had fond affection for Hartwick, they refused her application after consulting the school's students, players, and alumni. The students and alumni said that they would boycott the games. The players said they would have no confidence in her ability. Hartwick claimed sex discrimination. Podunk argued that requiring a man to fill the position of men's basketball coach is a bifokyu. Is it correct? No. The preference of the constituents of Podunk does not qualify as a bifokyu. Nancy Hartwick's qualification must be judged on its face alone. Gender preference may not play a part. Employment perspective. Gail Dudak is a sports reporter for the Minnesota Moon, an evening daily newspaper. Dudak had been covering women's sporting events, but now with the retirement of Charlie Schofield, she has been elevated to the major team sports. Her first assignment is a pro basketball game. During the game, Shorty Williams scores his 25,000th point. After the contest, all the reporters are rushing into the locker room to interview Williams. Dudak is refused entry because the men are changing and showering and she is a woman. Dudak files a claim with the Equal Employment Occupation Commission, EOC, alleging pro basketball is discriminating against women reporters. The team argues that the closed-door policy toward women is a bifokyu. Is her claim viable? Yes. The locker room policy makes it impossible for a woman to be a first-rate reporter. The team must either allow unrestricted entry or forbid all reporters from the locker room and conduct all interviews in the press room where equal access can be given. Employment perspective. Roger Bishop is a registered nurse at Sumner County Hospital. Bishop is on duty one evening when Mildred Dirksen calls for assistance. When Bishop attempts to assist Dirksen, she admonishes him that she called for a nurse. Bishop explains that he is a nurse, but she wants no part of him. Bishop asks Dirksen about the fact that she would have no problem having him touch her if he were a physician. The next day, Dirksen's family complains to the hospital administration, and Bishop is assigned to an all-male ward. The hospital justifies its action by asserting it is a bifokyu. Bishop claims that this behavior is discriminatory because female nurses are not confined to servicing exclusively female patients. Who is correct? Bishop. The hospital's action was not justified. Facts do not apply to one sex, but not the other. Hospitals cannot discriminate in deference to their patients' preferences. The patients must accept the hospital staff as long as those individuals are qualified. What if Dirksen's request concerned applying medication to or washing the genital area? Every accommodation should be made in this regard if there are female nurses available. Respecting privacy is important. But patients who are hospitalized are attended by the physicians on duty, and these physicians, who are predominantly male, view a patient's private parts if the need arises and the patient's private physician is not available.
Go back. Hold on a second.
Another option is for Dirksen to hire employment perspective. Gail Dudak is a sports reporter for the Minnesota Moon, an evening daily newspaper. Dudak had been covering women's sporting events, but now with the retirement of Charlie Schofield, she has been elevated to the major team sports. Her first assignment is a pro basketball game. During the game, Shorty Williams scores his 25,000th point. After the contest, all the reporters are rushing into the locker room to interview Williams. Dudak is refused entry because the men are changing and showering and she is a woman. Dudak files a claim with the Equal Employment Occupation Commission, EOC, alleging pro basketball is discriminating against women reporters. The team argues that the closed-door policy toward women is a bifokyu. Is her claim viable? Yes. The locker room policy makes it impossible for a woman to be a first-rate reporter. The team must either allow unrestricted entry or forbid all reporters from the locker room and conduct all interviews in the press room where equal access can be given. Employment perspective. Roger Bishop is a registered nurse at
absolutely
Sumner
disagree
County
with
Hospital.
that.
Bishop is on duty one evening
Like,
when
Displaced
Mildred
needs to
Dirksen
come
calls
in
for
here and
assistance.
explain to me how
When
that's
Bishop
not a
attempts
thing.
to assist Dirksen, she admonishes him that she called for a nurse. Bishop explains that he is a nurse, but she wants no part of him. Bishop asks Dirksen about the fact that she would have no problem having him touch her if he were a physician. The next day, Dirksen's family complains to the hospital administration, and Bishop is assigned to an all-male ward. The hospital justifies its action by asserting it is a bifokyu. Bishop claims that this behavior is discriminatory because female nurses are not confined to servicing exclusively female patients. Who is correct? Bishop. The hospital's action was not justified. Facts do not apply to one sex, but not the other. Hospitals cannot discriminate in deference to their patients' preferences. The patients must accept the hospital staff as long as those individuals are qualified. What if Dirksen's request concerned applying medication to or washing the genital area? Every accommodation should be made in this regard if there are female nurses available. Respecting privacy is important. But patients who are hospitalized are attended by the physicians on duty, and these physicians, who are predominantly male, view a patient's private parts if the need arises and the patient's private physician is not available. So too with nurses. Another option is for Dirksen to hire a private duty female nurse. Customer preferences. Although we are in an age in which customer service and satisfaction rule, acceding to customer preferences for service by one gender to the exclusion of the other is contradictory to Title VI's prohibition against gender discrimination. Employment perspective. Tudor's, a sports bar and restaurant chain known for its voluptuous female servers, has recently received applications from Ken, Frank, and Nick, who seek employment as servers. Tutors polls its clientele, who resoundingly state that they will no longer frequent the premises if male servers appear. Tutors denies the positions to Ken, Frank, and Nick because of their gender. Ken, Frank, and Nick sue for sex discrimination, arguing that as long as they are otherwise qualified, they cannot be refused employment on the basis of their gender. Is the customer always right, and will Ken, Frank, and Nick be working at Tutors? Tutors would have to prove that its business is primarily entertainment that requires females to dress provocatively. This issue has been left in doubt in light of a settlement in a case involving a similar situation against Hooters restaurant. Job selection cannot be based on customer preference for a particular gender, otherwise, it is discriminatory. Employment perspective. Thomas Stockwell applies for a position with workouts for women only, a health club exclusively for women. He is denied employment because he is a man. The proprietors are concerned with respecting the privacy rights of women. They argue that requiring only women employees is a BFOQ. Stockwell argues that assisting women with fitness instruction, teaching aerobics, and performing desk duties do not qualify as a BFOQ. Besides, he adds, there are female employees available for locker room maintenance. Is he correct? Yes. The preference of women customers to refrain from working out in front of men does not qualify as a BFOQ sufficient enough to override perpetuating discrimination against men by requiring their exclusion from employment.
So this I can understand. So this one says that he can help them because it's aerobics performing duties, fitness instruction, teaching aerobics, right? Besides, there are female employees available for locker room maintenance. So this case acknowledges that female staff are to go into the locker room, but the earlier one says that any reporter can come in unless no reporters are allowed to go in. What the hell is that? I need to message this place. I'm struggling with this.
Sector weather alert. A large sandstorm is approaching.
Thomas Stockwell, Equal Pay. Case 10.6, 10.7. The Equal Pay Act of 1963 is an amendment to the Fair Labor Standards Act, which regulates child labor, minimum wage, and overtime pay. The Equal Pay Act prohibits the payment of different wages to men and women who are performing the same job. This act covers all types of job categories from clerical to executive. The jobs must be equal with regard to skill, knowledge, or experience, and the conditions under which the work is performed must be similar. For example, a person working overseas is entitled to a pay differential for the same job performed domestically. In the news, the Lilly Ledbetter Fair Pay Restoration Act of 2009, the Act, reversed a 2007 U.S. Supreme Court decision bearing Ledbetter's name that restricted the filing of claims for pay discrimination to 180 days from the day of hiring. Often employees do not learn of the pay disparity until much later. Supreme Court ruling cost Lilly Ledbetter more than $200,000 in wages and benefits. The act allows employees to file a claim within 180 days of receipt of each paycheck that the employee believes is unjust. President Obama explained that this bill is designed to bring equality to wages earned by women in the workplace. Women earn only slightly more than 3/4 of what men earn. Minority women earn even less. This amounts to tens of thousands of dollars over a woman's work life. Both the House, 250 to 177, and the Senate, 61 to 36, passed the act prior to President Obama's historic signing. What protection does this act offer for employees who do not become aware of a pay disparity until many years later? Source: Christina Bellantoni. Obama signs his first law on equal pay in workplace. Act amends window to file legal claims. Washington Times, January 30th, 2009, p. 6. Comparable worth. Comparable worth is an attempt to assign values to male-dominated and female-dominated jobs based on worth. Where the values are equated, equal pay would be required. The theory behind this doctrine was that most female-dominated jobs pay less than male-dominated jobs. This argument has not found favor with the courts because assigning values is arbitrary and interferes with payments based on supply and demand. Dress and grooming policies. When employers attempt to regulate grooming, that is, length of hair, beards, and mustaches, courts have usually found in favor of the employer. Their reasoning is that grooming codes are more closely related to the manner in which an employer decides to operate its business than to equal opportunity. Good grooming standards have always been required in the business world. Imagine walking into a bank and seeing a long-haired branch manager who has not shaved or showered and is wearing jeans and a wrinkled shirt. This kind of appearance is not allowed because it would not be a good business policy. Customers may lose confidence in the bank and move their accounts elsewhere. Arguments against grooming codes have come in the form of the First Amendment's rights of speech through personal expression, the 14th Amendment Equal Protection Clause, and Title VI's provision regarding terms and conditions of employment. Employment perspective. Richard Masters is 29 years old, and he is becoming bald. He is very self-conscious, so he has started wearing a hat all the time. Masters works as a bond trader for Bulls and Bears Incorporated. Although his manager empathizes with Masters' dilemma, and he files a claim with the EOC. Will he win? Probably not. Masters is not being subjected to discrimination because of his disability. If Masters is harassed by coworkers, he may register a complaint of harassment. That is not the problem here, though. It revolves around Masters' vanity and his own perception of himself. This reasoning cannot outweigh Bulls and Bears' maintenance of dress codes as the way it conducts its business. Employment perspective. Mary Jo Worthington, a longtime customer at Grassmere Bank, is informed by Felix Farnsworth that he will be leaving the branch for a new position. On Monday, his replacement will begin work. When Worthington enters the bank on Monday, she is horrified to see a man with long hair who has neither showered nor shaved, is wearing jeans, cowboy customer service department, reporting what she saw. Nicholson is informed of the bank's grooming policy and is told never to be seen like that again. The next day, Mickelson looks the same and, therefore, is immediately terminated. He files a Title VII claim with the EOC, asserting that his actions are protected by freedom of speech through personal expression. Nicholson also claims that the grooming policy as a term and condition of employment is discrimination. Is he correct? No. Although there have been conflicting cases, the bank will be able to enforce its grooming policy because it is requiring of Mickelson only what is considered to be the norm in U.S. business. He is not being deprived of an equal opportunity. He is only being asked to conform to the generally accepted standards of society. Ethical issue. The case of dressing for success. A man named Lockhart wore facial jewelry to work. His supervisor informed him that this was prohibited, citing a company dress and grooming rule that permitted women facial jewelry, but denied it to men. Lockhart was terminated after he refused to comply. Lockhart argued that this policy discriminates against men. Louisiana Pacific Corporation retorted that treating men and women differently because of characteristics that are unalterable is discriminatory. However, it asserted that length of hair, use of jewelry, and choice of attire do not fit into that narrow exception. Lockhart v. Louisiana Pacific Corporation, 795 P2 D602, or App 1940. Questions. Was Lockhart's conduct ethical? Should this matter have been considered serious enough to require Lockhart's discharge? Is the use of dress codes ethical? Employment perspective. Sonia Hendricks was a trader at First Financial in Buffalo. The company dress code requires women to wear skirts, dresses, or suits with skirts. In the winter, the temperature is often below freezing. Hendricks wore pants to keep her legs warm. First Financial dismissed her for being uncooperative. Hendricks claimed that the dress code manifested sex discrimination because it forced women to show their legs and to be subjected to the cold weather. Is she correct? Probably. This restriction places an undue burden on women in that it does not give them the choice to protect themselves from the cold during the winter months. First Financial's business reasons are not paramount to a woman's health. However, First Financial may suggest that women wear leg warmers or tights under their skirts or dresses, and then remove them upon arriving at work. There is no definitive answer to this scenario. Brenna Lewis versus Heartland Inns of America, LLC. 591 F.3 D1033, 2010 U.S. App, Lexus 1283, 8th Circuit. Case 10.1. The issue is whether sexual stereotyping is permissible in the workplace. Murphy, circuit judge. Alleging that she lost a job she had done well solely because of unlawful sex stereotyping, Brenna Lewis brought this action for sex discrimination and retaliation against her former employer Heartland Inns of America, its director of operations and its human resource director, collectively Heartland, based on Title VII and state law. The district court granted summary judgment to Heartland. We reverse and remand. A summary judgment must be reviewed de novo, viewing the evidence in the light most favorable to the non-moving party and giving that party the benefit of all inferences that may reasonably be drawn. Heartland Inns operates a group of hotels, primarily in Iowa. Brenna Lewis began work for Heartland in July 2005 and successfully filled several positions for the chain for a year and a half before the actions at issue here. She started as the night auditor at Heartland's Waterloo Crossroads location. At that job, she worked at the front desk from 11 p.m. to 7 a.m. There were also 2 other shifts for guest service representatives, the A shift from 7 a.m. to 3 p.m. and the B shift from 3 p.m. to 11 p.m. Lewis manager at Waterloo Crossroads, Linda Gowdy, testified that Lewis did her job well and that she had requested a pay raise for her. Heartland recorded 2 merit-based pay raises for Lewis. The record also indicates that Gowdy received a customer comment praising Lewis. On or about December 7, 2006, Lewis began working various part-time front desk shifts at Heartland Inns located near Des Moines, including at Ankeny and Altoona. At both locations, she was valued by her direct supervisors. Her manager at the Altoona Hotel, Jennifer Headington, testified that Lewis made a good impression. She offered her a full-time night auditor position after receiving telephone permission from Barbara Cullinan, Heartland's director of operations. Lori Stiefel, Lewis manager at the Ankeny Hotel, testified in her deposition that Lewis did a great job in Ankeny, fit into the front desk, positioned really well, and was well liked by customers. Stiefel received permission over the phone from Cullinan on December 15th to offer Lewis a full-time A-shift position. Neither Headington nor Stiefel conducted an interview of Lewis before extending their offers, and the record does not reflect that Cullinan ever told them a subsequent interview would be necessary. Lewis accepted the offer for the A-shift at Ankeny and began training with her predecessor, Morgan Hammer. At the end of December 2006, Lewis took over the job. Lewis' positive experience at Heartland changed only after Barbara Cullinan saw her working at the Ankeny desk. As the director of operations, Cullinan had responsibility for personnel decisions and reported directly to the general partner of Heartland. She had approved the hiring of Lewis for the Ankeny A shift after receiving Stiefel's positive recommendation. After seeing Lewis, however, Cullinan told Stiefel that she was not sure Lewis was a good fit for the front desk. Cullinan called Stiefel a few days later and again raised the subject of Lewis' appearance. Lewis describes her own appearance as slightly more masculine, and Stiefel has characterized it as an Ellen DeGeneres kind of look. Lewis prefers to wear loose-fitting clothing, including men's button-down shirts and slacks. She avoids makeup and wore her hair short at the time. Lewis has been mistaken for a male and referred to as tomboyish. Cullinan told Stiefel that Heartland took 2 steps back when Lewis replaced Morgan Hammer, who has been described as dressing in a more stereotypical feminine manner. As Cullinan expressed it, Lewis lacked the Midwestern girl look. Cullinan was heard to boast about the appearance of women staff members and had indicated that Heartland staff should be pretty, a quality she considered especially important for women working at the front desk. Cullinan also had advised a hotel manager not to hire a particular applicant because she was not pretty enough. The front desk job description in Heartland's personnel manual does not mention appearance. It states only that a guest service representative creates a warm, inviting atmosphere and performs tasks such as relaying information and receiving reservations. Point 1. In her conversation with Stiefel about Brenna Lewis, Cullinan ordered Stiefel to move Lewis back to the overnight shift. Stiefel refused because Lewis had been doing a phenomenal job at the front desk. The following week, on January 9, 2007, Cullinan insisted that Lori Stiefel resign. Around this time, Heartland informed its general managers that hiring for the front desk position would require a second interview. Video equipment was also purchased to enable Cullinan, or Christy Nosbich, Heartland's human resource director, to see an applicant before extending any offer. When Lewis' former manager at Altoona, Jennifer Headington, raised a question about the new arrangements, Cullinan answered that hotels have to have a certain personification and appearance. Cullinan met with Brenna Lewis on January 23, 2007. At this point, Lewis had held the front desk job for nearly a month after Cullinan's initial approval of her hire for the position. The record contains no evidence of any customer dissatisfaction with Lewis or her service. Nevertheless, Cullinan told Lewis at the meeting that she would need a second interview in order to confirm/endorse her shift position. Lewis was aware from Lori Stiefel of what had been said about her appearance, and she protested that other staff members had not been required to have second interviews for the job. Lewis told Cullinan that she believed a second interview was being required only because she lacked the Midwestern girl look. She questioned whether the interview was lawful, and she cried throughout the meeting. Cullinan wanted to know who had told Lewis about the comment and asked whether it was Lori Stiefel. Thereafter, Cullinan talked about the need for new managers when revenue is down like in Ankeny, where Stiefel was the manager. Lewis responded that recent policy changes by Heartland, including bans on smoking and on pets, might explain the loss in revenue. Cullinan then encouraged Lewis to share more of her views about the new policies and took notes on what she said. 3 days later, Lewis was fired. Lewis does not challenge Heartland's official dress code, which imposes comparable standards of professional appearance on male and female staff members, and her termination letter did not cite any violation of its dress code. The theory of her case is that the evidence shows Heartland enforced a de facto requirement that a female employee conform to gender stereotypes in order to work the A shift. There was no such requirement in the company's written policies. In its termination letter to Lewis, Heartland asserted that she had thwart, Ed, the proposed interview procedure, and exhibited hostility toward Heartland's most recent policies. Lewis denies those charges and denies that those were the real reasons for her discharge. There were no customer complaints about Lewis' performance as a desk clerk, nor had there been any disciplinary action against her before she was fired. Lewis asserts that Heartland terminated her for not conforming to sex stereotypes and contends that this conduct violated Title VII of the Civil Rights Act of 1964 and the Iowa Civil Rights Act of 1965, ICRA. Heartland was not entitled to prevail on summary judgment unless it showed that plaintiff Brenna Lewis had not produced direct or circumstantial evidence which could reasonably support an inference of discrimination. To make a prima facie case under the McDonnell-Douglas framework, Lewis had to show that 1. She was a member of the protected group. 2. She was qualified to perform the job. 3. She suffered an adverse employment action. And 4. Circumstances permit an inference of discrimination. Such a showing creates a presumption of unlawful discrimination, requiring Heartland to produce a legitimate non-discriminatory reason for its employment action. The burden then returns to Lewis to prove that Heartland's proffered reason for firing her is pretextual. The parties agree that Lewis' ICRA and federal claims are analytically indistinguishable. The Supreme Court has stated that key critical issue in a sex discrimination case is whether members of one sex are exposed to disadvantageous terms or conditions of employment to which members of the other sex are not exposed. We recognize that remarks at work that are based on sex stereotypes do not inevitably prove that gender played a part in a particular employment decision. The plaintiff must show that the employer actually relied on her gender in making its decision. Lewis met this burden at the summary judgment stage. She provided evidence that the comments she cites were not stray remarks in the workplace, statements by non-decision makers, or statements by decision makers unrelated to the decisional process itself. Cullinan was a primary decision maker with authority to hire and fire employees. While several individuals also took part in the decision to terminate Lewis, they relied on Cullinan's description of her January 23, 2007, conversation with Lewis. Cullinan consistently indicated that female front desk workers must be pretty, and she criticized Lewis' lack of the Midwestern girl look in the same conversation in which she ordered Stiefel to move Lewis back to the night audit. Cullinan authorized Stiefel to hire Lewis over the phone, but demanded a confirm/endorse interview once she saw Lewis' tomboyish appearance. She demanded Stiefel's resignation after she refused to remove Lewis from her position. Evidence that Heartland's reason for the termination were pretextual include the fact that Lewis had a history of good performance at Heartland. She had no prior disciplinary record and had received 2 merit-based pay raises. The 2 individuals who supervised her during the majority of her employment at Heartland both stated that they had no problem with her appearance, and at least one customer had never seen customer service like that Lewis had provided. On this record, a fact finder could infer a discriminatory motive in Heartland's actions to remove Lewis. In addition to establishing a prima facie case
Oh my god, oh my god, oh my god!
has also shown a genuine factual dispute about whether Heartland's legitimate non-discriminatory reason for her termination was pretextual. On the record here, a reasonable fact finder could disbelieve Heartland's proffered reason for terminating Lewis. Heartland asserts that it fired Lewis because of the January 23rd meeting when Cullinan informed her that she would need to submit to a second interview. Lewis and Cullinan, the only 2 individuals in the room, portray the encounter in starkly different terms. On summary judgment, we must construe the conversation in the light most favorable to Lewis, however. Lewis denies that she expressed hostility to Heartland's policies or spoke in a disrespectful way or took an argumentative stance or refused to participate in a second interview. It is also relevant that the meeting occurred after Cullinan had given Stiefel the understanding that Lewis' appearance was not what she wanted on the front desk, and after Stiefel had shared that discussion with Lewis. Shortly after Cullinan's conversation with Stiefel about Lewis' appearance, Heartland procured video equipment so that Cullinan or Nosbich could inspect a front desk applicant's look before any hiring. Heartland's termination letter to Lewis only relied on the January 23rd meeting she had with Cullinan. Only later did Heartland allege poor job performance would justify her termination. Lewis asserts further that Heartland did not follow its own written termination procedure, which includes assessing the employee's previous disciplinary record, Lewis had none, and conducting an investigation before making the termination decision. Christy Nosbich, Heartland's equal employment officer responsible for directing investigations of employment discrimination, knew that Lewis had complained that Cullinan's requirements were illegal. but she nonetheless relied on Cullinan's account of their meeting without asking Lewis for her own. At this stage of the case, the question is not whether Lewis will prevail on her claim, but rather whether she has offered sufficient evidence from which a reasonable fact-finder could find that she was discriminated against because of her sex. We conclude that she has, for an employer who discriminates against women because they do not wear dresses or makeup, is engaging in sex discrimination because the discrimination would not occur but for the victim's sex. Companies may not base employment decisions for jobs such as Lewis on sex stereotypes, just as Southwest Airlines could not lawfully hire as flight attendants only young, attractive, charming women dressed in high boots and hot pants. As the Supreme Court stated, we are beyond the day when an employer could evaluate employees by assuming or insisting that they matched the stereotype associated with their group. We turn next to Lewis' retaliation claim. Title VII prohibits employers from retaliating against employees who oppose discriminatory practices. The burden-shifting McDonnell-Douglas analytical framework applies to this inquiry as well, beginning with the three elements of a prima facie case of retaliation, whether 1. The plaintiff engaged in protected conduct, including opposition to an action prohibited by Title VII, 2. She was subjected to an adverse employment action, and 3. There is a causal nexus between the protected conduct and the adverse action. In making out a prima facie retaliation claim, Lewis need not prove the merits of the underlying claim of sex discrimination. She can establish protected conduct as long as she had a reasonable, good faith belief that there were grounds for a claim of discrimination. Lewis went into the January 23rd meeting with Cullinan after learning about the Midwestern girl look comment. Lewis had already held her job for nearly a month and understood that other transferred employees in her situation had not been required to submit to a second interview. She observed Cullinan grow defensive after she asked her about the Midwestern girl look comment. Heartland argues that its official policy dictated a second interview, but Lewis has raised a genuine fact issue about whether Heartland imposed second interviews in similar circumstances before January 2007 and whether Heartland began doing so in relation to Cullinan's interaction with Lewis. Heartland suggests that Lewis' comments during the January 23rd meeting did not actually oppose any unlawful practice. Cullinan testified, however, that Lewis had emphatically stated that she thought it was illegal for us to ask her to interview and illegal for us to schedule her to another shift, and that Lewis said she thought the interview demand was because of her appearance. These statements cannot reasonably be characterized as anything other than opposition to a legal action. No one questions that Lewis was subjected to an adverse employment action, and there is ample record evidence to support a causal nexus between that and Lewis' protests at the January 23rd meeting. Lewis received the termination notice a mere 3 days after the disputed conversation, and Heartland cited her objection to the second interview in her termination notice. The evidence of pretext already discussed applies with equal force in evaluating whether Lewis has made out a prima facie retaliation claim. In sum, we conclude that Lewis has presented sufficient evidence to make out a prima facie case on her claims for sex discrimination and retaliation, and a sufficient showing at this stage that Heartland's proffered reason for her termination was pretextual. Accordingly, we reverse the judgment of the district court and remand for further proceedings. Judgment for Lewis. Case commentary. The Eighth Circuit determined that an employer that uses sexual stereotyping as a reason for discharging an employee is guilty of sex discrimination. Case questions. Are you in agreement with the court's decision? Is feminine appearance a justifiable criterion in employment selection? Is there an ethical resolution to this dilemma? Lori Chadwick v. Wellpoint, Incorporated. 561 F.3D38, 2009 U.S. App, Lexus 6426, U.S. Court of Appeals First Circuit. Case 10.2. The issue is whether Lori Chadwick was overlooked for the promotion because she had small children. Stall, Circuit Judge. Lori Chadwick brought a claim of sex discrimination under Title VII against Wellpoint, Incorporated after she was denied a promotion. She alleged that her employer failed to promote her because of a sex-based stereotype that women who are mothers, particularly of young children, neglect their jobs in favor of their presumed childcare responsibilities. Chadwick was a longtime employee of Wellpoint, an insurance company, in its main office. She was hired by Wellpoint in 1997 and was promoted in 1999 to the position of Recovery Specialist 2, which involved the pursuit of overpayment claims and claims for reimbursement from third parties. In 2006, encouraged by her supervisor, she applied for a promotion to a management position entitled Recovery Specialist Lead, or Team Lead. In this position, the successful candidate would be responsible for the recovery function for the region encompassing Maine, New Hampshire, and Connecticut. Because Chadwick was already performing several of the responsibilities of the team lead position, and based on her supervisor's comments, Chadwick believed she was the frontrunner for the position. In addition, on her most recent performance evaluation in 2005, she had received excellent reviews, scoring a 4.40 out of a possible 5.00 points. There were 2 finalists for the team lead position, Chadwick and another in-house candidate, Donna Owlett. While Chadwick had held the Recovery Specialist 2 position for 7 years, Owlett had only been promoted to that position about a year earlier. In addition, Owlette had scored lower than Chadwick, though satisfactorily, on her most recent performance review, receiving a 3.84 out of a possible 5.0 points. 2006, encouraged by her supervisor, she applied for a promotion to a management position entitled Recovery Specialist Lead, or Team Lead. In this position, the successful candidate would be responsible for the recovery function for the region encompassing Maine, New Hampshire, and Connecticut. Because Chadwick was already performing several of the responsibilities of the team lead position, and based on her supervisor's comments, Chadwick believed she was the frontrunner for the position. In addition, on her most recent performance evaluation in 2005, she had received excellent reviews, scoring a 4.40 out of a possible 5.00 points. 3 managers interviewed the 2 finalists, Linda Brink, who had previously supervised and worked closely with Chadwick, Don Leno, the director of recovery, and Nancy Miller, Chadwick's immediate supervisor. Nancy Miller was the ultimate decision-maker for the promotion, but she considered input from Brink and Leno in reaching her decision. Based on her own perceptions and those of Brink and Leno, Miller graded Owlette's interview performance higher than Chadwick's. Miller subsequently offered the promotion to Owlette over Chadwick. At the time of the promotion decision, Chadwick was the mother of an 11-year-old son and 6-year-old triplets in kindergarten. There is no allegation, insinuation, or for that matter evidence that Chadwick's work performance was negatively impacted by any childcare responsibilities she may have had. Indeed, Miller, the decision-maker, did not know that Chadwick was the mother of young triplets until shortly before the promotion decision was made. Apparently, Chadwick's husband, the primary caretaker for the children, stayed home with them during the day while Chadwick worked. He also worked off-hour shifts, presumably nights and weekends, when Chadwick was at home with the children. During the same period, Chadwick was also taking 1 course a semester at the University of Southern Maine. Chadwick alleges that Wellpoint denied her the promotion based on the sex-based stereotype that mothers, particularly those with young children, neglect their work duties in favor of their presumed childcare obligations. To support this claim, Chadwick points to the fact that she was significantly more qualified for the promotion than was Owlette, and also highlights 3 statements made by management around the time of the promotion decision. First, on May 9, 2006, 2 months before the decision was reached, Miller, the decision-maker, found out that Chadwick had 3 6-year-old children, in addition to an 11-year-old son. Miller sent an email to Chadwick stating, "Oh my, I did not know you had triplets. Bless you." Second, during Chadwick's interview with Brink, her former supervisor, she was asked how she would respond if an associate did not complete a project on time. Unhappy with Chadwick's answer, Brink replied, "Lori, you are a mother, ... W, would you let your kids off the hook that easy if they made a mess in their room? W, would you clean it or hold them accountable?" Third, and most important, when Miller informed Chadwick that she did not get the promotion, Miller explained, "It was nothing you did or didn't do. It was just that you're going to school, you have the kids, and you just have a lot on your plate right now." In her deposition, Miller said that she decided not to promote Chadwick because she interviewed poorly, and that she, Miller, only told Chadwick that she had too much on her plate in an ill-advised attempt to soften the blow. Here, Chadwick alleges that the subclass being discriminated against based on sex is women with children, particularly young children. Ultimately, regardless of the label given to the claim, the simple question posed by sex discrimination suits is whether the employer took an adverse employment action at least in part because of an employee's sex. In the simplest terms, unlawful sex discrimination occurs when an employer takes an adverse job action on the assumption that a woman, because she is a woman, will neglect her job responsibilities in favor of her presumed childcare responsibilities. It is undoubtedly true that if the work performance of a woman, or a man, for that matter, actually suffers due to childcare responsibilities, or due to any other personal obligation or interest, an employer is free to respond accordingly, at least without incurring liability under Title VII. However, an employer is not free to assume that a woman, because she is a woman, will necessarily be a poor worker because of family responsibilities. The essence of Title VII in this context is that women have the right to prove their mettle in the work arena without the burden of stereotypes regarding whether they can fulfill their responsibilities. Particularly telling is Miller's comment that it was nothing you did or didn't do. After all, the essence of employment discrimination is penalizing a worker not for something she did, but for something she simply is. A reasonable jury could infer from Miller's explanation that Chadwick wasn't denied the promotion because of her work performance or her interview performance, but because Miller and others assumed that as a woman with 4 young children, Chadwick would not give her all to her job. This inference is supported by several facts. First, the decision-maker learned of Chadwick's 3 6-year-olds just 2 months before she denied Chadwick the promotion. The young age and unusually high number of children would have been more likely to draw the decision-maker's attention and strengthen any sex-based concern she had that a woman with young children would be a poor worker. In sum, we find that Chadwick has put forth sufficient evidence of discrimination that a reasonable jury could conclude that the promotion denial was more probably than not caused by discrimination. We only conclude that Chadwick has presented sufficient evidence of sex-based stereotyping to have her day in court. Given the common stereotype about the job performance of women with children and given the surrounding circumstantial evidence presented by Chadwick, we believe that a reasonable jury could find that Wellpoint would not have denied a promotion to the new job, given the kids and her schooling. Case commentary. The First Circuit ruled that the statements referencing Chadwick's motherhood were sufficient for a jury to conclude that she was denied a promotion because of her small children. Case questions. Are you in accord with the court's reasoning? Do you believe Miller was trying to soften the blow when she referenced Chadwick's children? If Chadwick received the promotion, would Wellpoint have to accommodate her with regard to the needs of her children?
Azul El.
Henry and Terry J. Lewis versus Milwaukee County. 539F.3D 573. 2008 U.S. App. Lexus 17724. U.S. Court of Appeals 7th Circuit. Case 10.3. The issue is whether a policy requiring officers to be of the same sex as the juveniles they are supervising on the night shift is a BFOQ. Ripple, Circuit Judge. BFOQ. In 1997, Milwaukee County's Juvenile Detention Center, JDC, instituted a... In 1997, Milwaukee County's Juvenile Detention Center. Case 10.3. The issue is whether a policy requiring officers to be of the same sex as the juveniles they are supervising on the night shift is a BFOQ. Ripple, Circuit Judge. BFOQ. In 1997, Milwaukee County's Juvenile Detention Center, JDC, instituted a policy that required each unit of the facility to be staffed at all times by at least one officer of the same sex as the detainees housed on that unit. Because there were far more male units than female units at the facility, this policy had the effect of reducing the number of shifts available for female officers. Ursula Henry and Terry Lewis, both female officers at the facility, brought this action in the United States District Court for the Eastern District of Wisconsin, alleging sex discrimination and retaliation in violation of Title VII. After a bench trial, the district court concluded that the gender-specific policy was based on a bona fide occupational qualification and that no other discrimination or retaliation had occurred. Accordingly, it entered judgment in favor of the county. For the reasons set forth in this opinion, we reverse the judgment of the district court. The new JDC contains common rooms, classrooms, and recreation rooms where the juveniles spend the majority of their daytime hours. At night, however, the juveniles are confined to their living areas, which are assigned based on their sex, age, and classification. The living areas at the new facility are organized into 7 single-sex pods. Each can accommodate between 11 and 22 juveniles of the same sex. Each pod consists of a number of individual cells, a control center desk from which the staff can monitor the cells and communicate with the pod via intercom, and a common area or day room with tables, chairs, and a television. The individual cells each contain a bed, a toilet, a desk, and a small storage area. The entire cell, including the toilet, is visible from the outside through a window in the cell door. Prior to the move to the new facility, JCOs, juvenile correction officers, had been assigned to shifts without regard to the sex of the officer. Mr. Wanta's new policy, however, required that each pod be staffed at all times by at least one JCO of the same sex as the juveniles housed on the pod. During the day shifts, when 2 JCOs staffed each pod, one of the 2 JCOs could be of the opposite sex. However, during the night shifts, when only one JCO staffed each pod, the sole JCO on duty had to be of the same sex as the juveniles in the pod. Because the JDC housed far more male juveniles than female juveniles, Mr. Wanta's same-sex role model/mentoring policy afforded male JCOs more opportunities for work than those available to female JCOs. The night shift was particularly problematic. It was perceived as the easiest shift. Those officers assigned to it received premium pay, and it afforded the most opportunities for overtime. During the time of their employment as JCOs, Ms. Henry and Ms. Lewis primarily worked one of the day shifts. Prior to 1997, however, they each had earned a substantial amount of additional income from voluntary overtime, predominantly by working the night shift. According to a collective bargaining agreement, voluntary overtime at the JDC traditionally had been apportioned according to seniority. Employees with the most seniority could put in for overtime, and they would receive the first opportunities to work their preferred shifts. Ms. Lewis and Ms. Henry were relatively senior employees, and they often were able to work overtime at the old JDC. After Mr. Wanta instituted the same-sex pod policy, however, far fewer women were allowed to work the third shift because there were far fewer female pods than male pods at the facility. As a result of the same-sex role model/mentoring program, most of the available night shifts with premium pay were reserved for male employees. Female officers like Ms. Henry and Ms. Lewis no longer were able to get the same number of overtime hours as they previously had received. Instead, male employees with less seniority were allowed to work these shifts. Consequently, Ms. Henry and Ms. Lewis received significantly less compensation than they had received prior to the institution of the same-sex role model/mentoring program. Ms. Henry and Ms. Lewis brought this action in the district court. They alleged that, in violation of Title VII, they had been denied overtime assignments on the third shift at the JDC because of their sex. We agree that the administrators of juvenile detention facilities, like the administrators of female correctional facilities, are entitled to substantial deference when fashioning policies to further the goals of the facility. We do not agree, however, that the discretion accorded to these individuals in either context is effectively unlimited. A defendant ultimately must introduce sufficient evidence to prove that the administrator's judgment that a particular sex classification is reasonably necessary to the normal operation of the institution is the product of a reasoned decision-making process based on available information and experience. We must conclude that Milwaukee County's contention that sex-based assignments are reasonably necessary to achieve these goals, at least on the third shift, is not supported by the record before us. The employer, Milwaukee County, has the burden to demonstrate that it could not rearrange job responsibilities to eliminate or minimize the conflict between the inmates' privacy, security and rehabilitation interests, and the employee's rights under Title VII. The evidence in the record does not support the conclusion that the juvenile's safety or security, or the institution's ability to manage risk effectively, was at all in jeopardy because of the presence of opposite-sex JCOs on the third shift. The record establishes, however, that there has not been a single instance of staff-on-inmate sexual assault at the JDC on any shift by either sex, nor has there been a significant problem with false accusations against the staff. Furthermore, other safety precautions, such as door alarms and the presence of supervisors, runners, and video cameras, currently are working to prevent actual and alleged security breaches. Although Milwaukee County contends that a staff member may be able to circumvent the alarm system in order to enter a juvenile cell at night, the record contains no evidence that this contingency has occurred or was likely to occur at the JDC. The record affirmatively shows that the JDC allowed JCOs of the opposite sex to monitor the pods during both of the daytime shifts. It is undisputed that the vast majority of the time that the juveniles were unclothed occurred during these daytime shifts. Showering generally took place during the second shift, when members of the opposite sex were permitted to staff the pods. The only showering that occurred on the third shift was monitored by one of the runners who performed the intake procedures. The juveniles were provided with pajamas, which they were required to wear at night. They changed into this attire on the second shift, and they changed out of it on the first shift again, while JCOs of the opposite sex were permitted to view them. Although Milwaukee County presented testimony that third shift JCOs occasionally viewed juveniles using the toilet, masturbating, or otherwise acting out sexually, it is undisputed that this situation occurred on the first and second shifts as well. Accordingly, we must conclude that the county failed to meet its burden to prove that the sex-based classification at issue here was reasonably necessary for the rehabilitation, security, or privacy functions of the JDC. Therefore, Milwaukee's BFOQ defense must fail. The JDC's third shift policy adversely affected the plaintiff's employment. It is undisputed that overtime pay had been a significant and expected component of the plaintiff's compensation prior to the institution of the sex-based policy. Not only did the majority of overtime work available occur on the third shift, but the third shift also offered a 50-cent per hour pay premium. Accordingly, the dramatic reduction in the opportunity for women to work on the third shift constituted an adverse employment action. Because the JDC's third shift policy adversely affected the plaintiff's employment opportunities, we must conclude that it is in violation of Title VII. Case commentary. The Seventh Circuit ruled that a BFOQ did not exist because there was no evidence of any incidents concerning juveniles and officers of the opposite sex. Case questions. Do you agree with the court's decision? Why was the warden overruled if he believes this policy will prevent incidents from occurring? Do you believe that if an incident occurred, the warden would be allowed to implement his policy? Gina Duckworth versus St. Louis Metropolitan Police Department. 2007 U.S. App, Lexus 17137, 8th Circle. Case 10.4. The issue in the case that follows is whether assigning female police officers to the night watch is a bona fide occupational qualification. Benton, Circuit Judge. 3 female officers sued their superiors for gender discrimination under Title VII of the Civil Rights Act of 1964 and the Missouri Human Rights Act. The district court denied the defense of qualified immunity to the police superiors. This court reverses and remands. After a transfer left no female officers on the night watch in District 1, Captain Antoinette M. Filla asked if any female officers would work then. None volunteered. For months later, Captain Filla assigned plaintiff Sandra Delaney to the night watch. Delaney was the least senior of the experienced female officers in the district. After working the night watch for 2 months, Delaney complained that her husband was called up for military duty and she had difficulty obtaining a babysitter. On February 6, 2003, Captain Filla emailed all personnel, "I believe there is a definite need for female officers on the night watch." On the advice of Major Roy Joachim Staler, her immediate superior, she assigned the 3 plaintiffs, based on seniority, to work the night watch, initially rotating for 28-day periods. On February 10th, plaintiffs filed a grievance. "We believe it is unfair to order us based upon our gender to rotate monthly on the night watch. This order is in violation of rules manual designated in Section 3.114, where it is mandated that police officers be permanently assigned to a platoon. This order is also in violation of Title VII of the Civil Rights Act of 1964, wherein it is illegal to discriminate against employees in regards to sex, when the policy is applied in terms of condition of employment, including placement. On February 14th, Captain Phila explained her position in an inter-department report to the plaintiffs and her superiors. I believe the assignment of females to all watches is imperative to the operation of any command, not just patrol operations. It is not only important that all watches in every command be as diverse as the population we serve, but also as diverse as the entire population of our police department. The unique operations of law enforcement also requires unique responsibilities by female and male officers, responsibilities which no other profession requires. We have to consider the safety of all personnel on the street when assigning our officers to crucial positions, for example, the searching of suspects at incident scenes. I currently have 15 female officers, 6% of authorized strength, assigned to District 1, with none assigned to the Night Watch. We felt it was important to have our females assigned strategically to cover several recreation brackets of all watches. As authority, Captain Phyllis cited Special Order 90, S7, which provides, district commanders may reassign an officer from her assigned work schedule provided the commander has sufficient justification to do so. Her resolution to this grievance is to assign three female officers, plaintiffs, to the Night Watch permanently, with one in each of the 3 precincts. Plaintiffs received a 10% pay increase while working the Night Watch. On February 25th, plaintiffs filed a second grievance, claiming the permanent placement on the Night Watch was retaliation for their original grievance. Captain Phila rejected the grievance. Your assignment to the Night Watch was based on the district's needs and operations, not on personal issues. Viewing the facts favorably to plaintiffs, there is direct evidence of gender discrimination. Captain Phila emailed all personnel, I believe there is a definite need for female officers on the Night Watch. On the advice of Major Joachim Staehler, she reassigned only females to work the Night Watch. Chief Makwa directly participated in the reassignments by approving them. For a gender-based classification to withstand equal protection scrutiny, it must be established at least that the challenged classification serves important governmental objectives and that the discriminatory means employed are substantially related to the achievement of those objectives. In this case, Captain Phila's inter-department report identifies 2 governmental objectives. First, she believed it was important that all watches in every command be as diverse as the population we serve. Second, Phila aimed to consider the safety of all personnel on the street when assigning our officers to crucial positions, for example, the searching of suspects at incident scenes. The record here does not demonstrate the importance of these objectives. The next step in the qualified immunity analysis is to ask whether the right was clearly established in light of the specific context of the case. Reasonable mistakes can be made as to the legal constraints on particular police conduct. If the officer's mistake as to what the law requires is reasonable, the officer is entitled to the immunity defense. Reasonable police administrators could believe that assigning female officers to the Night Watch was lawful. Here, although the plaintiffs were impermissibly reassigned without an exceedingly persuasive justification, the decision, although mistaken, was reasonable. The issue is not whether the defendant acted wrongly, but whether reasonable persons would know they acted in a manner which deprived another of a known constitutional right. Based on the defendant's reasonable judgments, qualified immunity should have been granted. The judgment of the district court is reversed in part, and the case remanded. Judgment for St. Louis Metropolitan Police Department. Case commentary. The 8th Circuit Court reasoned that the decision to assign female police officers to the Night Watch was reasonable. Therefore, qualified immunity should be granted to Captain Phila. Case questions. Do you agree with the court's determination? Is it a befocus to have female police officers on the Night Watch? How could this dilemma be resolved in an ethical manner? Tracy Lust v. Seeley, Incorporated. 383 F.3D 580. 2004 U.S. App. Lexus 18830. U.S. Court of Appeals 7th Circuit. Case 10.5. The issue in this case is whether a supervisor can make stereotypical assumptions in deciding to award a promotion to a man over a woman. Posner, Circuit Judge. Tracy Lust sued her employer, Seeley, the mattress manufacturer, for sex discrimination in violation of Title VII. A jury returned a verdict in her favor, awarding her $100,000 in compensatory damages and $1 million in punitive damages. Pursuant to 42 U.S.C. Section 1981A, B, 3D, which places a ceiling of $300,000 on the total damages that may be awarded in an employment discrimination case against the largest employers, the judge reduced the total damages award to $300,000, to which she added $1,500 in back pay, which is not within the statutory meaning of damages. Lust was a sales representative who has been employed in Seeley's Madison, Wisconsin office since 1992. Her supervisor, Scott Penters, regarded her highly. In 2000, an opportunity opened up for promotion to Key Account Manager in Chicago, the key account being a mattress retailer called Bedding Experts. The appointment would have represented a significant promotion for Lust, who had repeatedly expressed to Penters her avid desire to become a key account manager. Instead, the job went to a young man. 2 months later, after Lust filed her discrimination claim with the EOC, Seeley offered her, and she accepted a key account manager's position in the Madison office. It is because of the short delay in her obtaining the promotion that the award of back pay was so small. The jury's finding that lust was passed over because of being a woman cannot be said to be unreasonable. Penters had a history of making sexist remarks to lust, such as, "Oh, isn't that just like a woman to say something like that?" Or, "You're being a blonde again today," or, "It's a blonde thing." Lust is blonde. Seeley points out irrelevantly that blondes are not a statutorily protected class, which will disappoint hair colorists. More important, once when she expressed an interest in a promotion even though she had just gotten married, Penters was surprised and asked her why Jerry, her husband, wasn't going to take care of her. Most important, Penters admitted that he didn't consider recommending Lust for the Chicago position because she had children and he didn't think she'd want to relocate her family, though she hadn't told him that. On the contrary, she had told him again and again how much she wanted to be promoted, even though there was no indication that a key account manager's position would open up anytime soon in Madison. Realism requires acknowledgement that the average mother is more sensitive than the average father to the possibly disruptive effect on children of moving to another city. But the anti-discrimination laws entitle individuals to be evaluated as individuals rather than as members of groups having certain average characteristics. It would have been easy enough for Penters to ask Lust whether she was willing to move to Chicago rather than assume she was not, and by so assuming prevent her from obtaining a promotion that she would have snapped up had it been offered to her. Penters, it is true, didn't decide who would be promoted to key account manager. His superior, Al Bolden, did. And Bolden testified that he had passed over Lust for the Chicago position because he thought her deficient in interpersonal skills and unlikely to want to move to Chicago, given the number of X's in her relocation chart. In any event, the purity of Bolden's own motives was placed in issue, though perhaps not very convincingly. Since inability to get along with customers couldn't have been cured immediately, the speed with which Bolden reclassified an account as a key account in order to make Lust a key account manager when she accused the company of sex discrimination and seemed, and in fact was, about to sue might seem powerful evidence that Bolden didn't really think that Lust lacked good interpersonal skills. It's actually weak evidence because the promotion may have been motivated by a desire, which would have been consistent with continued doubts about Lust's suitability for promotion, to head off a lawsuit or mitigate the amount of back pay and damages that might be awarded. This was not an admission of liability, but an attempt to mitigate damages after the jury had found liability. Lust could and did use the quick promotion to impeach Bolden's testimony about her inadequate interpersonal skills. Another boomerang argument by Seeley is that the staff at Betting Experts, the key account that Lust would have managed had she been given the Chicago position, consisted of foul-mouthed animals. There had been an incident several years earlier with a different account, at which Lust's effort to divert a customer from talking about his sexual activities with his ex-wife and about the strip bar that he owned so enraged the customer that he rolled up the agenda of their meeting and threw it at her. Whereupon she left and the account was given to another sales rep, a man. One possible inference is that Lust is too prissy for Seeley's roughest customers. But another is that Seeley merely assumes that women can't deal with foul-talking men, and that is an impermissible assumption, another example of stereotypical thinking. No doubt more women than men would have trouble bonding with macho mattress dealers, but there are tough women. Women now fly combat missions for the Air Force, and maybe Lust, who is at least brave enough to go by her husband's last name, is one of them. Notwithstanding the incident with the strip bar owner, and his behavior was so egregious that it is merely a conjecture that a male Seeley rep could have pacified him, or that Lust's male successor on the account did so. Penters or Bolden could have explained to Lust the character of the Betting Expert staff and probed her ability to handle such people. Instead, they merely assumed that she could not. They would not have assumed that about a man, even a man who had walked out of a customer's office when the customer pelted him. We are concerned that to uphold the award of the maximum damages allowed by the statute in a case of relatively slight, because quickly rectified, discrimination would impair marginal deterrence. If Seeley must pay the maximum damages for a relatively minor discriminatory act, it has no monetary disincentive, setting aside liability for back pay, to escalate minor into major discrimination. It's as if the punishment for robbery were death, then a robber would be more inclined to kill his victim in order to eliminate a witness and thus reduce the probability of being caught and punished. Because if the murdering robber were caught, he wouldn't be punished any more severely than if he had spared his victim. In light of this consideration and this court's treatment of punitive damages awards in similar cases, we believe that the maximum such award that would be reasonable in this case would be $150,000. To summarize, the judgment is affirmed except with respect to the award of punitive damages, as to which Seeley is entitled to a new trial unless the plaintiff accepts a remitter of the excess of those damages over $150,000. Case commentary. The Seventh Circuit ruled that Seeley was guilty of favoring a man over Tracy, lust for a promotion based on assumptions made about her personal life. Case questions. Are you in agreement with the decision of the court? Are there ever any circumstances in which a supervisor is entitled to make a decision to promote based on a subordinate's personal life? Because Tracy Lust received a promotion tantamount to what she wanted, should she be entitled to any damages? Lily M., Ledbetter v. The Goodyear Tire and Rubber Company, Incorporated. 550 U.S. 618, 2007 U.S. Lexus 6295, U.S. Supreme Court. Case 10.6. The issue is whether past discrimination for disparity in pay is actionable in the present. Justice Alito delivered the opinion of the court. Petitioner Lily Ledbetter worked for Respondent Goodyear Tire and Rubber Company, Goodyear, at its Gadsden, Alabama, plant from 1979 until 1998. During much of this time, salaried employees at the plant were given or denied raises based on their supervisor's evaluation of their performance. In March 1998, Ledbetter submitted a questionnaire to the EOC alleging certain acts of sex discrimination, and in July of that year, she filed a formal EOC charge. After taking early retirement in November 1998, Ledbetter commenced this action, in which she asserted, among other claims, a Title VII pay discrimination claim and a claim under the Equal Pay Act of 1963, EPA. Ledbetter introduced evidence that during the course of her employment, several supervisors had given her poor evaluations because of her sex. That as a result of these evaluations, her pay was not increased as much as it would have been if she had been evaluated fairly, and that these past pay decisions continued to affect the amount of her pay throughout her employment. Toward the end of her time with Goodyear, she was being paid significantly less than any of her male colleagues. Goodyear maintained that the evaluations had been non-discriminatory, but the jury found for Ledbetter and awarded her back pay and damages. On appeal, Goodyear contended that Ledbetter's pay discrimination claim was time-barred with respect to all pay decisions made prior to September 26, 1997, that is, 180 days before the filing of her EOC questionnaire. And Goodyear argued that no discriminatory act relating to Ledbetter's pay occurred after that date. The Court of Appeals for the 11th Circuit reversed, holding that a Title VII pay discrimination claim cannot be based on any pay decision that occurred prior to the last pay decision that affected the employee's pay during the EOC charging period. The Court of Appeals then concluded that there was insufficient evidence to prove that Goodyear had acted with discriminatory intent in making the only two pay decisions that occurred within that time span, namely, a decision made in 1997 to deny Ledbetter a raise and a similar decision made in 1998. Ledbetter filed a petition for a writ of certiorari, but did not seek review of the Court of Appeals holdings regarding the sufficiency of the evidence in relation to the 1997 and 1998 pay decisions. Rather, she sought review of the following question: whether and under what circumstances a plaintiff may bring an action under Title VII of the Civil Rights Act of 1964 alleging illegal pay discrimination when the disparate pay is received during the statutory limitations period, but is the result of intentionally discriminatory pay decisions that occurred outside the limitations period. Similarly, she maintains that the 1998 decision was unlawful because it carried forward the effects of prior, uncharged discrimination decisions. Reply brief for Petitioner 20. In essence, she suggests that it is sufficient that discriminatory acts that occurred prior to the charging period had continuing effects during that period. Brief for Petitioner 13, ACH paycheck that offers a woman less pay than a similarly situated man because of her sex is a separate violation of Title VII with its own limitations period. Regardless of whether the paycheck simply implements a prior discriminatory decision made outside the limitations period, see also reply brief for Petitioner 20. This argument is squarely foreclosed by our precedents. Ledbetter's arguments here, that the paychecks that she received during the charging period and the 1998 raise denial each violated Title VII and triggered a new EOC charging period, cannot be reconciled with Evans, Ricks, Lawrence, and Morgan. Ledbetter, as noted, makes no claim that intentionally discriminatory conduct occurred during the charging period or that discriminatory decisions that occurred prior to that period were not communicated to her. Instead, she argues simply that Goodyear's conduct during the charging period gave present effect to discriminatory conduct outside of that period. But current effects alone cannot breathe life into prior, uncharged discrimination. Such effects in themselves have no present legal consequences. Ledbetter should have filed an EOC charge within 180 days after each allegedly discriminatory pay decision was made and communicated to her. She did not do so, and the paychecks that were issued to her during the 180 days prior to the filing of her EOC charge do not provide a basis for overcoming that prior failure. Ledbetter places significant weight on the EPA, which was enacted contemporaneously with Title VII and prohibits paying unequal wages for equal work because of sex. Ledbetter suggests that we should hold that Title VII is violated each time an employee receives a paycheck that reflects past discrimination. The simple answer to this argument is that the EPA and Title VII are not the same. In particular, the EPA does not require the filing of a charge with the EOC or proof of intentional discrimination. Ledbetter originally asserted an EPA claim, but that claim was dismissed by the district court and is not before us. If Ledbetter had pursued her EPA claim, she would not face the Title VII obstacles that she now confronts. We apply the statute as written, and this means that any unlawful employment practice, including those involving compensation, must be presented to the EOC within the period prescribed by statute. For these reasons, the judgment of the Court of Appeals for the 11th Circuit is affirmed. Justice Ginsburg, with whom Justice Stevens, Justice Souter, and Justice Breyer joined, dissenting. Lily Ledbetter was a supervisor at Goodyear Tire and Rubber's plant in Gadsden, Alabama, from 1979 until her retirement in 1998. For most of those years, she worked as an area manager, a position largely occupied by men. Initially, Ledbetter's salary was in line with the salaries of men performing substantially similar work. Over time, however, her pay slipped in comparison to the pay of male area managers with equal or less seniority. By the end of 1997, Ledbetter was the only woman working as an area manager, and the pay discrepancy between Ledbetter and her 15 male counterparts was stark. Ledbetter was paid $3,727 per month. The lowest paid male area manager received $4,286 per month. The highest paid, $5,236. Any annual pay decision not contested immediately, within 180 days, the court affirms, becomes grandfathered, a fait accompli beyond the province of Title VII ever to repair. The court's insistence on immediate contest overlooks common characteristics of pay discrimination. Pay disparities often occur, as they did in Ledbetter's case, in small increments, cause to suspect that discrimination is at work develops only over time. Comparative pay information, moreover, is often hidden from the employee's view. Employers may keep under wraps the pay differentials maintained among supervisors, no less the reasons for those differentials. Small initial discrepancies may not be seen as meat for a federal case, particularly when the employee, trying to succeed in a non-traditional environment, is averse to making waves. Pay disparities are thus significantly different from adverse actions such as termination, failure to promote, or refusal to hire, all involving fully communicated discrete acts, easy to identify as discriminatory. It is only when the disparity becomes apparent and sizable, e.g., through future raises calculated as a percentage of current salaries, that an employee in Ledbetter's situation is likely to comprehend her plight and, therefore, to complain. Her initial readiness to give her employer the benefit of the doubt should not preclude her from later challenging the then current and continuing payment of a wage depressed on account of her sex. On questions of time under Title VII, we have identified as the critical inquiries what constitutes an unlawful employment practice and when has that practice occurred. Our precedent suggests, and lower courts have overwhelmingly held, that the unlawful practice is the current payment of salaries infected by gender-based or race-based discrimination, a practice that occurs whenever a paycheck delivers less to a woman than to a similarly situated man. Yet, under the court's decision, the discrimination Ledbetter proved is not redressable under Title VII. Each and every pay decision she did not immediately challenge wiped the slate clean. Consideration may not be given to the cumulative effect of a series of decisions that, together, set her pay well below that of every male area manager. Knowingly carrying past pay discrimination forward must be treated as lawful conduct. Ledbetter may not be compensated for the lower pay she was in fact receiving when she complained to the EOC. Nor, were she still employed by Goodyear, could she gain, on the proof she presented at trial, injunctive relief requiring, prospectively, her receipt of the same compensation men receive for substantially similar work. The court's approbation of these consequences is totally at odds with the robust protection against workplace discrimination Congress intended Title VII to secure. This is not the first time the court has ordered a cramped interpretation of Title VII, incompatible with the statute's broad remedial purpose. Once again, the ball is in Congress's court. As in 1991, the legislature may act to correct this court's parsimonious reading of Title VII. For the reasons stated, I would hold that Ledbetter's claim is not time-barred and would reverse the 11th Circuit's judgment. Case commentary. The U.S. Supreme Court held that past discrimination based on inequity of pay must be filed with the EOC within 180 days to be actionable. 4 of the 9 justices dissented. Case questions. Are you in agreement with the decision of the court? Do you believe the statute of limitations does not make sense in a pay disparity case that has evolved over many years?
I
Do you
might have to
believe
listen to
Congress
this
should
whole
modify
thing
the time
over
limit
again.
for filing a case with the EOC regarding pay disparity cases? Polly and Heller versus Elizabeth Forward School District. 2006 U.S. App, Lexus 13547, U.S. 3rd Circuit Court of Appeals. Case 10.7. The issue is whether the school district had a valid explanation for paying younger male teachers higher salaries than it was paying 3 female teachers who were over 50 years of age. Nygaard, Circuit Judge. The school district's salary scale and the collective bargaining agreement between the school district and the teachers' union sets different steps in salary depending on a teacher's experience, education, and teaching certification area. When the school district hired plaintiffs, they were all over the age of 50 years old, and they were all hired at step 1 of the district's salary scale. They alleged that after the school district hired them as teachers, it hired 7 other teachers, comparators, 5 of whom were male and all of whom were younger, with substantially the same qualifications as plaintiffs, at higher salary steps. When making out a prima facie case, a plaintiff need only show that the jobs being compared are substantially equal, not necessarily that they're identical. The EPA defines what constitutes equal work as jobs that require equal skill, effort, and responsibility. Additionally, when a court assesses the substantial equality between jobs, it should rely on actual job performance and content rather than job descriptions. Moreover, because of the heavily fact-driven character of the inquiry, substantial equality must be determined on a case-by-case basis. Depending on the facts and the evidence presented, the proper comparator might be another teacher within the same certification class. A school district may have a particular need, justifying pay differentials, to hire teachers certified in specific subject areas. Here, as we noted earlier, the plaintiffs established their prima facie case for both their EPA and ADA claims. Therefore, any claim by the school district that the plaintiffs had no evidence that any of the comparator teachers were hired at higher than Step 1 because of their gender or age is inapt. Trial Superintendent Mueller was unable to explain what the school district had meant when, in its answer to the PHRC complaint, it proffered 3 reasons for the hiring discrepancies. He could not explain what applicable law could have required the salary differences. He did not know who had suggested experience as a possible justification, and he admitted that the reason given for the hiring of Ms. Stock at a higher level was false. He also testified that the specialized certification rationale for the hiring of the comparator teachers was new and that it did not apply to Ms. Stock, even though in the school district's answer, he had claimed that it did. He also testified that the school district had changed its reason for the hiring discrepancies. Furthermore, when pressed on his claim that the scarcity of applicants necessitated the higher salaries, he was unable to testify as to how many other teachers had applied for the position or even how many were considered. He also suggested that hiring Ms. Stock at a higher salary step was motivated by loyalty for her short-term substitute teaching. Additionally, 3 school board members testified that they did not know why many of the teachers were hired at their pay steps. Because the record clearly suggests that there was no cohesive or consistent answer to the question why the comparator teachers were hired at significantly higher salaries, a jury could have found that the school district's proffered non-discriminatory reasons were unbelievable, and, consequently, we will affirm the district court's denial of the motion for judgment as a matter of law. The district court granted plaintiffs' request to be placed higher up on the pay scale, in line with their comparators. It is well settled that the district court has discretion to fashion equitable relief to effectuate the purposes of the Title VII statutory scheme, specifically in order to award make-whole damages. Moreover, where, as here, the jury makes explicit findings that, had the discrimination not occurred, the plaintiffs would have been at higher salary steps, a district court may appropriately fashion an award of damages to support this finding. Thus, the district court's decision here to place the plaintiffs in the same position as their comparators was not an abuse of discretion. In summary, and for the reasons set forth above, the judgment of the district court will be affirmed. Case commentary. The Third Circuit decided that the Vernonia School District's explanation was invalid, which means the district was guilty of violations of the ADA and the Equal Pay Act. Case questions. Do you agree with the reasoning of the court in this case? If the salary the school district offered was acceptable to the women over 50 years of age, but not to the younger male teachers, and the school district needed the male teachers, what would you think? What would be an appropriate ethical resolution to this case? Summary. In the past, American society excluded women from many positions in the labor market because it could afford to do so. The United States was the most affluent society in the world, but its economy was flourishing almost exclusively at the hands of men. In today's global environment, no brain can be left untapped. Women should be encouraged by society to realize their potential in the workplace. Some men fear that employing women in business will reduce the number of positions for them. Their fear is misdirected. Us against them should not mean men against women. It should mean keeping jobs in the United States as opposed to outsourcing them overseas. If the power of each U.S. citizen, whether male or female, is not used to its fullest so that people become innovators and entrepreneurs to develop newer, faster, cheaper, and better products, services, and technologies, then the positions that men are trying to safeguard from women will be lost to overseas competitors. The point to realize is that the number and quality of jobs are elastic and can expand or contract depending upon how well we as a country perform. Human resource advice. Formulate grooming standards and dress codes. Treat men and women in a consistent manner. Eliminate stereotypes when employing and/or assigning men and women to particular jobs. Identify instances of sex plus discrimination. Pay women an amount equal to men when the qualifications needed and the work performed are similar. Know that FOX exist only in a very limited number of instances, such as for bathroom or locker room attendance. Realize that customer preferences cannot dictate hiring selections with regard to sex. Learn that comparable worth has never been implemented in employment. Encourage women to realize their full potential in the workplace. Understand that men may also be victims of sex discrimination.
Well, that was a lot. That was a lot.
Weather alert. A large sandstorm is approaching.
Oh, that looks cool. All right, so this is the one we're going to make. Oh, I have a mental. I have this style of suit already. There we go. All right, now I just got to get gloves and boots, which all comes from the exact same area that we've been working on. Yeah, I can destroy this. Oh, the recycler's been enabled this whole time. Rip. Well, that's the end of my homework. I guess I can turn off this window. I'm going to have to listen to that chapter again. There was a lot of stuff in there that seemed like... I don't know how to say it, but just like, I couldn't understand it. Like, I literally wound up messaging Displaced about it. Like, dude, this doesn't make sense. Like, why is this and this when they seem to have the same principle behind what they're saying? But maybe that's just me being stupid. I don't know. I am not sure. But it feels good getting some decent... I feel like I'm getting some really good, decent gear now. Got a really good sword. We got the Mark V welder. I like the passive suspense belt. Like, I don't know particularly why somebody would not have that, but whatever. Disable. So as long as our blood purifier is running, we can't turn those off. Because I just realized I probably got to turn the game up. Whoops. Hold on, I got an alt tab here. There we go. Yeah, there's like no sound from the game for you all. There. That should fix that. I've got to play for like at least 22 minutes. I think I'm about to go steal some more blood from people. If I'm being honest. How's it all blood? Like, I know the unit is full, but I needed to throw it into my storage containers. Deposit all blood. Because, like, these are essentially empty. Which is, you know, my thing, because... I take it back. Let me try repairing with that real quick. There we go. There we go. All right. Big day at work tomorrow. Big day at work tomorrow. Oh my god, an amount of iron ore. Or copper wire, I think is what I need is. Which is fabricated here? Yep, welding wire. Oh, welding wire uses salvaged metal. Okay, let's enable. Yeah, I'm forever going to turn those off. Like, I'm not going to use them for anything. Especially because you use them so infrequently. Oh, that's the benefit of the higher welder. It's faster, which feels like a duh statement. God, that uses so much more wire, though. I do need to go repair these two things, though, real fast.
Who goes now?
I need backup.
God, that's such a creepy device. The way it just pulsates. We haven't seen a sandworm in a while. We haven't ridden on the sand in a while. Like, legitimately have not done anything with the sandworms. There's one.
Someone's here.
Okay. I don't feel like I was standing in the fire on that, but you know what? Whatever. That's fine. Okay. Okay, we're at 21 out of 87. You are currently processing just fine. We'll turn that off. Redeposit this. I feel like I should fly out and get a little bit more radioactive stuff. Gypsum, jasmine, whatever it's called. That is to the south area. Interesting that there's like no testing grounds out here, but granted, like Yeah, it's going to be in all those high pocket areas. Do I need a pill for... I think there's a pill for that. To deal with the radiation? Yeah, let's go grab some... Let's switch suits here real fast. We're gonna go... We're gonna go grab some jasmine. Before we do, because I want to kind of be efficient about this. Oops, nope. It's interesting to me how you have to vulture when they only did that like once. All right, let's look at the map. I think we're heading in the right direction. Yeah, we're heading in the right direction. So I think I want to do an assault thropter next so I can get boost and storage on it at the same time. Yeah, we're coming to the southern point here. So I need to start banking directly west. Too hot there. Oh. Come on, it's right here. All right, so that's pretty much full. So now we're gonna spawn in the ship. I don't feel like landing for just one. Running around a nuclear waste. I was about to say, oh my god, don't tell me my ship doesn't react in this environment. Nah, that's too greedy. You know what? I think it's time to leave. I'm about quarter full. I'm gonna leave the area. Let the radiation die off. And then we'll come back and grab a couple more. Quick in, quick out. Easy peasy. It's funny how quickly that falls off the screen, too. It's going to take a lot of water, too. Like, I didn't realize how much water that whole process takes. Yeah, it looks like the rest of it's in these little pockets. Not bad. Slightly a little over a quarter. There's one down here. Doesn't look like there's one there, but that's fine. Realize I'm just bunny hopping, but bunny hopping is working for us today. We're gonna have to get out of here at like a quarter because we are on the other side of it now. So like, oh, there's another 3-banger. All right, so we'll do the last 3-banger here, and then we'll just get out of here. Than I want, but this is their last grab. And we are out of here. Oh, another 3. Unfortunate. Staring at my health bar right now. No way! I didn't know you died immediately. I thought it would give you rad poisoning or something. Okay, that's forgiving. Like, okay, so boots, gloves, hat, chest, money. I mean, oh, I'm almost full. Jeez, I didn't realize that at all. Wow, I didn't. Okay, that's so funny. It's like vehicle sets down, respawn at the vehicle. Yeah, and the vehicle didn't even take damage. Okay. How am I losing speed? Man, I thought I'd get a radiation status. I really thought that's what was going to happen. I gotta rename that one to raw ore as well. Okay, gypsum deposited. I don't think I have enough water to process it, unfortunately. I could process 100. Oh wait, did the body finish? Is that what that is? Oh, the body finished. Okay, so it shoved it into circuit. What are you guys up to? You're processing your stuff? Processing, that's fine. Let's drink. Then fill containers. Got it. Oh, that's close. Alright, so I have 800 crystal left. Wow. Alright, well, this thing will be making water then. Or making... Like, you should be empty. Yep. You should be empty. Yep. You're definitely empty, so we'll grab another one. And we'll see if... Alright. So this is working. So I need to grab 1, 2, 3. Turn off the vehicle, grab the extractor. So you're half full and filling. You're completely empty. So we're just going to do a quick run.
Identify yourself.
Well, thanks for playing. I really don't think there's much I can do with that. The sun is coming up. Hooray.
Reveal yourself. Being attacked. Who's that?
I think one thing that'd be nice is... You know what? I take it back. I was about to say if they had an air attack. I wonder if the air attack is bound to an ability, maybe? Come on. Come on. Get up there. Get up there. Get up there. Yeah. There you go. Pause it all. I just realized I have none in circuit. There we go. Okay, that's good. That's good. Because that'll fill up. That'll push out to the circuit. I mean, you're not. I guess this is the way it is. Like, I can't drink from this, can I? Oh, I can because it's pulling from everything. Okay. We're going to leave that to process. We're going to leave this to process. I should have only those two. That'll be good. You are refining. How long does that take you per unit, anyways? Does it say? Oh, 5 seconds? 4 seconds. 7 seconds. A plastinium ingot takes 900 water, or takes 1,000 water to bust out? Thanks. I'm just trying to think of what I can use that for to maybe do better. It's definitely getting close to bedtime because I've got to pee. So... What is that? Oh, is that a... Oh, it's a large refinery. I don't want large refinery. What do I need for this? I can make a large extractor. Which we might do. I might just wait for the duraluminum ingots to get finished being processed. Oh my god, that takes 350 by itself. I'd have to build so many power units just for this. Like, what does it do? What's the difference? Takes an hour. Total yield is 2,500. It takes 50 minutes. Oh, 4,500. That's why. Oh, that's so nice. Total yield's 25. Total yield's 40. 350. Yeah, I definitely can't run both of those at the same time. I would have to redo power, which I believe is where this comes into play. I need 3 spice melange. Yeah, I definitely don't understand that one. But I do understand the need for this. Ingots. Spice melange. I just need 3. I bet Arai has some. If I wanted to grab 3 from him, I could, but I don't want to yet. I could definitely build these. Wonder if this can fit outside where my other wind generators are. It can. But it needs something. So we're getting close to needing large generators and larger purifiers. That's what's happening. We're on the cusp of moving into one of the final areas we are heading towards now. Which means it's gonna be time to upgrade everything else. Alright, that is flooding into circuit. This isn't flooding into circuit. That is beginning the process. So let's make sure we have enough resources. No power. That is actively working. No power. No power. Look at the circuit over here. So this is good to go for 20 days. This is good to go for Alright, that's good to go. Let's double check my wind traps quickly. 7 days, we'll be back at these tomorrow. 7 days, we will be back at these tomorrow. Yeah, I don't think I can turn off these yet. No, because that'll deactivate power for everything. Okay, not a bad deal. Oh yeah, that's why there's no railings right here. I wanted to match the 3 of those. Oh, my ear itches. Ah. Yeah. We don't use too much power, honestly. If we only use 200, this is going to go for another 50 minutes, so that'll be fine. These I do leave on all the time. I do realize I leave these on all the time. I mean, 35 and 35 is a lot, but that's going to do it for now for me for stream. Thank you for hanging out during our book club tonight. Learning about sexual discrimination, or sex discrimination, I should say. Yeah, I'll be back tomorrow night. There'll be more stuff going on. More learning. So, yeah, we'll see everybody then.